Jeffrey Sumaya. Tama po?
Yes, attorney. Ako po.
Go ahead, Sir Jeff. Sige po.
Alright, so I'll begin.
Mr. Sumaya.
Yes, sir. I'll begin with the yung oath, lawyer's oath.
Huwag na mag-oath. Narinig na kita mag-oath eh.
Okay. Sige po.
Narinig na kita mag-oath, di ba?
Yes po.
Kasi
I'm through.
Okay na muna yun.
Yes, so...
Okay. Kasi medyo mahaba itong Francisco if you would be already discussing. Go ahead.
Yes, sir. Kind of lengthy case. Of Francisco, I also have the same question with Ate Rodiel. Why is it magmamalasakit? Pero this is a case between Francisco et al. Versus the House of Representatives and also et al. Because the Senate, and there are also other interveners in this case. Basically, this is a case assailing the constitutionality of the second impeachment complaint filed against then Chief Justice Hilario Davide. The case onset is held on June 22, 2003, when then President Erap Estrada filed an impeachment case against Chief Justice Hilario Davide and 7 other associate justices for supposedly disbursements of funds of the Supreme Court. This impeachment complaint was then forwarded to the Committee on Justice of the House of Representatives, and then later on, sometime in October, that's October 22 of the same year, 2003, the Committee on Justice found that the impeachment complaint filed by then President Estrada was sufficient in form. However, the Committee on Justice found it to be not sufficient in substance. And so therefore, per the impeachment rules of the House of Representatives of the 12th Congress, the same was not forwarded to the plenary. So it was dismissed after the Committee on Justice found it insufficient in substance. A day after that, October 23, the committee investigation on against then Chief Justice Hilario Davide was finished, and so therefore on October 23, a second impeachment complaint was filed again against Hilario Davide. That was 4 months. 4 months after the impeachment complaint filed by President Estrada had happened. This then created or arose several questions as to whether or not the second impeachment complaint would be constitutional. So, 18 petitions in total plus interveners have been gathered or collected by the Supreme Court and merged into one to be heard of. But essentially, their question is that is the second impeachment complaint violative of the provision of the Constitution? Specifically, the petitioners were questioning the constitutionality in regards to paragraph 5, section 3, Article 11 of the 1987 Constitution, which provides prohibition on filing more than one impeachment complaint or initiating more than one impeachment complaint against same official within a period of 1 year. And then here comes the respondents of the case, the main respondents of the case were the House of Representatives and also the Senate through then Senate President Drilon, my favorite. They argued that it's constitutional, but mainly the argument in the context of the book is whether the Supreme Court can exercise judicial review. The main contention of the respondent of the case is because if the Supreme Court would conduct a judicial review over the impeachment case, it would violate the principle of the separation of powers. In the ruling of the Supreme Court, they responded in affirmative. The second impeachment is unconstitutional, which was already discussed by Ate Rodiel, and also that the Supreme Court can exercise judicial review over the second petition. The Supreme Court held that using or raising the case of Angara versus Comelec, where the same court had held that the Constitution provides a definition of the powers of the branches of government, and so therefore it is the judiciary who is provided with the power to interpret this definition of the powers. And so therefore, Senator Aquilino Pimentel have also raised an issue that the Supreme Court, since the proceeding have yet to reach the Senate, as it is the one who is vested with the power to hear over an impeachment case, should exercise judicial restraint. But then the Supreme Court says, no, we cannot exercise judicial restraint. Otherwise, who will interpret and define these powers provided before the three branches of government? There's no other government agency that will define this but the judiciary. And so, as they ruled in the case of Angara versus Comelec, which is actually the definitive case that was used in hearing on this case, is that when the judiciary exercises its power of judicial review, it does not display as if display supremacy over the three branches of government. What it just does is it exercises both the duty and the obligation provided to it by no less than the Constitution. So, in short, the Supreme Court have ruled that the Supreme Court does not need to exercise judicial restraint. It should look into the case because we have all the elements of judicial review. You have an actual case there, you have the very least of the case, and you have the petitioners having locus standi. And so therefore, the Supreme Court agreed that they must look into it, as they are obliged by no less than the Constitution to interpret these definitions of the different powers of the three branches of government. So that was the case, sir. Thank you.